Okay? Let us continue our discussion on Revised Corporation Code of the Philippines. Now, let us discuss yung one-person corporation. Actually, yung OPC or the one-person corporation is actually a special corporation. Kaya meron siyang separate title under RA 11232. Now, definition class ng OPC. Sabi diyan, one-person corporation is a corporation with a single stockholder. Kaya lumalabas, ikaw yung stockholder, ikaw din yung lumalabas na board of director, okay? Ikaw din lumalabas na president, okay? Now, yung OPC, nag-issue ang SEC ng SEC Memorandum Circular number 7-2019. At nag-took effect ito noong May 1, 2019. Okay, upon publication sa Manila Standard and Manila Bulletin. Okay, now term of existence. Ang OPC, by the way class, ang pwede lang kasi mag-organize ng OPC is only natural person, estate, and trust. Unlike sa ordinary corporation, di ba, nakalagay doon is any person, corporation, partnership, or association. Okay? Pero dito sa OPC, only natural person, estate, and trust may organize an OPC. Now, ilang class yung term of existence niya? Pag ang OPC is created by a natural person, perpetual life siya. Pero pag trust or estate siya, okay, pag lumalabas trust or estate, bali co-terminus daw siya sa existence ng trust or estate. Kaya ibig sabihin kung yung estate ay na-dissolve na, kasi di ba na-partition na yung property among the legal heirs. Okay, lumalabas, okay, terminated rin, okay, yung OPC. Kaya lumalabas proof of partition for judicial settlement yan, pero kung halimbawa extrajudicial, di lumalabas yung deed of extrajudicial settlement. Okay, nga kung OPC naman for instance is inorganized, okay, ng trust. Okay, lumalabas trust, under the name siya ng trustee. Di lumalabas, dissolve siya upon proof of termination of the trust. Now, okay, ulitin ko ha, ang pwede lang mag-form ng OPC is only natural person, trust, saka estate. Pero by the way, class may mga corporation na hindi pwedeng i-organize as an OPC. Okay, bawal ang banks, okay, quasi-banks, pre-need, trust, insurance, public and publicly listed companies, non-chartered government-owned and controlled corporation, mga GOCC itong created under general laws, and of course, natural person for purpose of exercising a profession. Kaya halimbawa si A, practicing CPA. Okay, nang nag-took effect yung RA 11232, okay, he want to transform his practice from sole proprietor into a corporation setup. Okay, is that allowed? The answer is no. Kasi ang pwede lang is general professional partnership. Kahit na ina-allowed yung OPC, hindi pa rin pwedeng i-organize, okay, ang corporation, okay, for the exercise of profession. And of course, non-bank financial institution. Okay? Yung non-bank financial institution, hindi yan kasama doon sa RA 11232. Okay? Makikita mo yan dinagdag doon sa section 13 sa SEC Memorandum Circular number 7. Now, what are the characteristics of OPC? First, hindi sa required ng minimum, okay, authorized capital stock. Okay? Pero syempre subject yan sa applicable laws and regulations. Second, hindi sila required mag-submit ng corporate bylaws. Kasi sa ordinary corporation, dapat pa rin silang mag-submit ng or mag-adapt ng corporate bylaws. Ang tinanggal lang dun sa batas is okay yung 30 days. Kaya medyo mas mahaba yung period ng corporation mag-adapt ng corporate bylaws in case nag-decide silang mag-adapt ng corporate bylaws after the issuance na ng Certificate of Incorporation. Okay, another required row to indicate the letters OPC. Kasi mandatory dapat yung extension word nila, no, extension yung name nila, that may extension word na OPC or one-person corporation para ma-distinguish sila, okay, na sila ay OPC, not an ordinary corporation. Okay, another, the single stockholder shall be the sole director and president of one-person corporation. Kasi lumalabas dito, ikaw na yung director, ikaw pa yung president. Pero ang question kasi dyan, under the okay, RA 11232, di ba? Okay, sa ordinary corporation, bawal kang maging president, secretary, and president, treasurer. Pero sa OPC, bawal ang president at the same time secretary ka, pero pwedeng president ka, pero self-appointed treasurer ka. Pero take note, kailangan yung mag-comply ng posting of bonds. Magpo-post kayo ng bonds. Okay, at ang sabi ng okay, circular, ang sabi dun, pag ang authorized capital stock mo is 1 peso to 1 million, 1 million ang ipopost mong bonds. 1 million 1 to 2 million, dapat mag-post ka ng bonds na 2 million. 2 million 1 to 3 million, magpo-post ka ng bonds na 3 million. 3 million 1 to 4 million, magpo-post ka ng bonds ng 4 million. Okay, 4 million 1 to 5 million, magpo-post pa ka ng bonds ng 5 million. Pag over 5 million na, kung magkano yung authorized capital stock, yun ang ipopost mong bonds. Pero take note, required kayong mag-post, okay, yung bonds requirement dito, required lang siya as long as ikaw ang self-appointed treasurer. Kaya for instance, nag-decide ka ng mag-appoint ng corporate treasurer. In that case, pwede na kayo mag-file ng petition for the cancellation of the bond. Okay, upon showing of proof that there is already appointed corporate treasurer. Okay, tapos syempre, magpa-file kayo ng amended, okay, information, okay, regarding change of officers. Okay, kasi meron ng appointed corporate treasurer. Okay, kaya sabi ng section 122, single stockholders may be a self-appointed treasurer of the corporation. Basta I repeat, you need to post a bond. Now, the single stockholder shall designate a nominee and alternate nominee, who shall in the event of single stockholders' death or incapacity, take the place of the single stockholders as directors and shall manage the corporation affairs. Actually, yung section 123, required yan kasi pag nag-organize ka ng OPC, naka-indicate doon sa article na meron kang designated nominee and alternate nominee. Now, bakit kailangan may alternate nominee? Kasi baka mamaya, yung nominee pa lang na designate mo, namatay din. Eh di wala na. Kaya in case namatay yung nominee or designated nominee nyo, meron pa kayong alternate nominee. Okay? Para bang email lang yan eh. Okay? Meron kang primary email, may secondary. Para in case nawala yung una, meron pang pangalawa. Okay, now, ito yung sinasabi ko sa yung posting of bonds requirements doon sa Memorandum Circular number 7. Sabi kasi ng section 10 nga doon, pag ang authorized capital stock is 1 to 1 million, mag-post ka ng band na 1 million, 1 million 1 to 2 million, 2 million, 2 million 1 to 3 million, 3 million, 3 million 1 to 4 million, 4 million, 4 million 1 to 5 million, 5 million. Pag over 5 million na, kung magkano yung authorized capital stock, iyan yung ipopost nyong bonds. Now, ito renewable to every 2 years or as may be required. Okay, pero kailangan nyo mag-submit ng audited financial statement. Okay, now certified under oath by the company's president and treasurer. Kasi di ba dito ang nangyari, ikaw yung president at the same time, okay, self-appointed treasurer. Now, the bonds is a continuing requirement daw. Meaning, required itong bonds na to as long as you are the self-appointed treasurer. Okay, pero pwede kayong magpa-cancel, okay, mag-file ng petition for cancellation ng bonds. Number 1, ito yung requirement, kailangan meron ng proof of appointment of another person as treasurer. Kasi kung nag-appoint na nga kayo ng corporate treasurer, pwede ka na magpa-cancel, okay, nung bond. At pangalawa, magpa-file kayo ng amended form for appointment of officers. Another characteristic ng OPC, required kayong mag-maintain ng minutes book para sa lahat ng action, decision, and resolution taken by one person corporation. Ngayon, audited financial statement, okay, kailangan ng audited FS dito, okay, as a rule. Pero pag halimbawa yung asset or liability daw is less than 600,000, then hindi na kailangan ng audited FS. Sufficient na ang certification under oath lang ng corporate treasurer, okay, and the president. By the way, dati kasi sa Batas Pambansa Bilang 68, di ba? Kapag ang paid up capital doon is less than 50,000 pesos, hindi kailangan ng audited financial statement. Okay, pero binago sa RA 11232. Ang ginawa pati doon is pag yung asset or liabilities na. Asset or liabilities is less than 600,000, hindi kailangan ng audited FS. Sufficient na yung certification under oath lang ng corporate, okay, treasurer. Okay, signed by the president. Okay, fiscal year of one-person corporation, kung ano yung nakaset dun sa article of incorporation. Pero pag walang naka-indicate, of course, we use calendar year. Now, the commission daw may place the corporation under delinquent status should the corporation fail to submit the reportorial requirement. Mapapansin mo sa ordinary corporation kasi, di ba? Sabi ko dyan, 552 yun, di ba? Bali, pag hindi kayo nag-formal organize at nag-commence ng business operation within 5 years, okay, dissolve ka. Okay, pero kung nagkaroon ng formal organization and commencement ng business operation, pero naging continuously operative kayo for a period of 5 years, then lumalabas, ipuput kayo under delinquent status. Now, 5 years yun sa ordinary. Dito naman, 5 years din actually, pero 3 years kapag, okay, failure for 3 consecutive times, tuloy-tuloy siya. Pero kung intermittent naman siya, okay, pwede halimbawa meron ngayon, next year nag-comply, tapos next year hindi na naman, next year nag-comply, bali 5 years naman siya. Okay. Now, okay, a sole shareholders claiming limited liability has the burden of affirmatively showing that the corporation was adequately financed. Now, ang problem class is this. Okay, syempre 'di ba, kung ikaw ay sole proprietor and you want to convert into a corporation for OPC, syempre ang main objective mo dyan is you want to organize a corporation in order to have what we call limited liability. Kasi pag sole proprietor ka, liable ka to the extent ng separate property. Pero dito kasi sa OPC, limited liability ka nga. Pero syempre ang burden of proof nasa iyo muna. Kailangan mo muna kasing i-establish dito na adequately finance ka, okay, nung nag-organize ka as an OPC. Otherwise, okay, lumalabas, unlimited liability ka pa rin. Okay, kaya yan yung section 130 ha. A sole shareholder claiming limited liability has the burden of affirmatively showing that the corporation was adequately financed para magkaroon ka ng limited liability. Okay, now the article of OPC, yung article of incorporation ng OPC, meron siyang content same dun sa section 14 for ordinary corporation. Pero meron kayong dinagdag dito, if the single stockholder is a trust or estate daw, lalagay niyo yung name, nationality, and residence ng trustee, administrator, executor, guardian, conservator, custodian, or other person exercising fiduciary duties, together with the proof of such authority to act on behalf of the trust or estate. Tapos nakalagay yung name, nationality, residence ng nominee and alternate nominee, and the extent, coverage, and limitation of the authority. Kasi yan, kailangan niya ilagay sa article yung nominee and okay, alternate nominee. Okay, ngayon, okay, within 15 days daw from the issuance of the certificate of incorporation, okay, yung OPC daw kailangan magkaroon kayo ng appointment ng corporate treasurer, okay, corporate secretary, and of course, other officer. Tapos dapat i-notify ang SEC within 5 days from the appointment. Sa ordinary corporation kasi 30 days yan, di ba? Okay, dito 5 days lang. Okay, using the appointment form as may be prescribed by the SEC. Now, the single stockholder may not be appointed as corporate secretary but may assume the role of a treasurer. Pero kailangan lang, pag ikaw ang self-appointed treasurer, I repeat, kailangan nyo mag-post ng bonds. Now, sabi ko, yung purpose ng nominee and alternate nominee, kasi nga ganito. Halimbawa, yung stockholder, for instance, single stockholders na matay. O, patay tayo dyan kasi lumalabas kung OPC, nag-iisa, dissolve kagad yung corporation. Kaya magkakaroon ng tinatawag na designated or lumalabas na nominee kasi siya yung magsasubstitute doon sa namatay na stockholder. Okay? Pero ang mangyayari dyan kasi, i-distinguish mo kasi yung permanent saka lumalabas yung temporary. Kasi halimbawa, katulad yan, permanent incapacity. Eh, syempre, death yan. Normally, death or permanent incapacity. Ibig sabihin talagang totally incapacitated na siya. Ang mag-a-apply dyan, ito. Bali ito, death or permanent incapacity. Ang mangyayari kasi dyan, kung death yan, okay, isa-substitute siya ng legal heirs. Pero syempre, ang mangyayari dyan, yung lumalabas na nominee muna ang magsa-substitute. Kasi maghihintay class yung nominee na magkaroon ng common agreement among the legal heirs, sino ba yung lalabas na magiging OPC. Kasi tandaan nyo kung there are several legal heirs, hindi naman pwedeng lahat sila ay maging stockholder. Kasi hindi na siya magiging OPC. Remember, in an OPC, there is only single stockholder. Kaya dapat magkaroon muna ng common agreement among the stockholders, okay? Among the legal heirs, sino yung magsa-substitute as OPC. Pero pag halimbawa, temporary lang yan. Halimbawa, itong stockholders na to, temporary na naging incapacitated siya. Now, in that case, automatic magsa-substitute yung designated nominee. Until, of course, the stockholder, which is the single stockholders, already gain capacity. Okay? Now, are foreign nationals allowed to form an OPC? Meaning foreign natural person. Allowed naman siya. Subject lang sa mga restriction provided by the Constitution as well as the pertinent laws and regulation. Okay? Yeah, subject to constitutional and statutory requirement. Kasi kung halimbawa, reserve lang yan for Filipino citizen, hindi yan pwedeng mag-organize ang foreign national. Now, ito yung reportorial requirement natin for an OPC. Kailangan nyo rin mag-submit sa SEC ng audited financial statement within 120 days from the end of its fiscal year, as indicated in the Article of Incorporation. Tapos dapat, audited financial statement, pero pag ang asset or liability is less than 600,000, sufficient na ang certification under oath ng corporate treasurer lang. Tapos, report on all explanation or comment daw by the President on the qualification, reservation, or adverse remark made by auditor in the financial statement, disclosure of all self-dealing and related party transaction entered into between the OPC and single stockholders, and of course, other report as the SEC may require. Okay, now punta tayo sa method of dissolution, section 117. Meron tayong tinatawag na voluntary resolution where no creditors affected, voluntary resolution where creditors affected, dissolution by shortening corporate term, and of course is involuntary dissolution. Okay, paki-check na lang yung voting requirement. Kasi laging tinatanong yung voting requirement. Of course, the general rule is for dissolution, okay, majority ng board of director plus at least 2/3 ng outstanding capital stock. Pero na iba, pagdating ngayon, may amendment kasi doon sa, ibig sabihin, binago yan doon sa RA 11232, pag yan ay voluntary dissolution wherein no creditors are affected, magiging majority ng board of director and majority ng outstanding capital stock na lang. Okay? Corporate liquidation naman, ang gusto ko lang tandaan nyo rito, pag halimbawa nag-expired yung term niya, kasi merong nakalagay kunwaring term na naka-indicate sa Article of Incorporation, okay, ang mangyayari dyan is that, okay, dissolve. Pero pwede kayo kasing mag-file ng petition for revival. Pero what if nag-decide na wag nang mag-file ng petition for revival? Now, in that case, meron tayong tinatawag na 3 years extended life. Okay? Bali, 3 years extended life, pero no longer for purpose of entering into business, but only for purpose of liquidation. Now, kaya lumalabas sabi dyan, general rule, every corporation whose charter expired pursuant to its article of incorporation is annulled by forfeiture or whose corporate existence is terminated in any other manner shall nevertheless remain a body corporate daw. Kaya lumalabas body corporate pa rin siya for 3 years. After the effectivity date of dissolution for the purpose of prosecuting and defending suit by or against it and enabling it to settle and close its affairs, dispose of and conveys property and distribute its asset but not for purpose of continuing the business for which it was established. Kaya ulitin ko yung 3 years extended life, no longer for continuing the business but only for purpose of liquidation. Exception, okay, for banks, okay, govern siya ng RA 7653 or the new Central Bank Act, saka yung RA 3591 which is the Philippine Deposit Insurance Corporation Charter. Okay, exception lang yung bank, saka under PDIC. Okay, ngayon sabi niyan, at any time during the said 3 years, the corporation is authorized and empowered to convey all its property to trustee for the benefit ng stockholder. Kaya basically, sa 3-year period, pwede mag-appoint ka ng designated trustee para siya mag-settle ng, okay, magkaroon ng, magbenta ng mga property, bayaran yung corporate creditors, at i-distribute yung surplus, if any, okay, among the stockholder. Okay, ngayon, sabi niya, upon the winding up of corporate affairs, any asset distributable to any creditor or stockholder or members who is unknown or cannot be found shall be escheated in favor of the national government. Okay, kaya mapapansin mo dito, halimbawa during liquidation process, okay, nililiquidate yung corporation, may mga stockholders kunwari, okay, as well as mga corporate creditors, okay, na hindi naman nagpakita within the 3-year period. Ang mangyayari kasi dyan, yan yung tinatawag na mga unclaimed balances. Okay, yung mga unclaimed balances na yan, ang mangyayari dyan, ma-escheat yan in favor of the national government. Kaya lumalabas yung national government, pwede silang mag-file ng, okay, petition for escheat proceeding. Special proceeding yan, yung escheat. Okay? Bali mangyari, i-forfeit na yon mga claims ng unclaimed balances in favor of the national government. Okay, dati kasi iba yung nakalagay sa BP 68 eh, in favor ng city or municipality kung nasaan yung location ng property. Pero dito naka-indicate as cheated in favor of the national government. Ngayon, except by decrease of capital stock or otherwise allowed by this code, no corporation shall distribute any of its asset or property except upon lawful dissolution and after payment of all debt and liabilities. Ang sinasabi lang ng batas sa Section 139 is, okay, general rule, bawal kayong mag-distribute or mag-return ng capital kasi violation niya ng trust fund doctrine. Kasi under the trust fund doctrine, the corporation is holding only the corporate asset as a mere trustee for the benefit of corporate creditors. Okay, pero sabi dyan, syempre, unless of course authorized by law. Okay, kung may balanse kayo ng unrestricted retained earnings. Okay, kaya yan ha, ibig sabihin, pag magdi-decrease kayo ng capital stock, bawal as a rule. Okay, except upon lawful dissolution and after payment of all its debt and liabilities. Kasi di ba may preference ang corporate creditors over the stockholder. Okay, now the last topic here is foreign corporation. Ito hindi rin masyadong tinatanong sa board exam. Okay, by the way, pag sinabing foreign corporation, ito yung corporation na inorganize under foreign law. Okay, kaya sabi dyan, foreign corporation is one form organized or existing under law other than those of the Philippines and whose laws allows Filipino citizens and corporation though to do business in its own country or state. Yeah, technically, lumalabas dapat may reciprocity. Now, resident agent daw, by the way, kasi one of the requirement kasi para makapag-operate ang foreign corporation here in the Philippines, okay, they need to appoint what we call a resident agent. Kasi yung resident agent, dyan isa-serve yung mga court processes in order for the Philippine court to acquire jurisdiction over this foreign corporation. At ano ang requirement ng qualification ng resident agent? Pag yan ay natural person, meaning individual, kailangan good moral character and sound financial standing. Pero pag yan ay juridical person, it must be a domestic corporation doing lawful business in the Philippines. Now, general rule class, a foreign corporation lawfully doing business in the Philippines shall be bound by all laws. Kaya ibig sabihin, yung foreign corporation, pag they are doing business in the Philippines, okay, kailangan nila comply daw lahat ng laws, rules, and regulation applicable to a domestic. Pero by the way, exception, walang pakialam ang Philippine government dito with respect to creation, formation, organization, or dissolution of corporation. Bakit? Kasi pagdating doon sa creation, formation, organization, dissolution, hindi naman yan create under Philippine law. Kaya ang mag-a-apply na batas sa kanila is the law creating them, which is a foreign law. Kaya kung create under US law yan, it means US law mag-a-apply sa kanila. Pangalawa, those which fix the relation, liabilities, responsibility, or duty of stockholder, member, officer of corporation to each other or to the corporation. Kaya yung mga intra-corporate controversy, okay, hindi rin mag-a-apply yung provision ng Philippine law. Okay, kaya ibig sabihin other than that, ang mag-a-apply, okay, same okay rule sa mga domestic corporation of the same class. Now, okay, ulitin ko ha, kapag ang foreign corporation, they are do business in the Philippines without a license, okay, ang legal effect lang yun is that they cannot sue, but they can be sued in any court or any administrative agency. Okay, kaya bago sila makapag-operate dito, okay, kailangan nila muna obtain ng license from the SEC. Okay, ngayon kung binigyan sila ng, okay, halimbawa binigyan na yung foreign corporation ng license to operate. Ang tanong kasi dyan is, pwede ba siyang i-revoke? The answer of course is yes. And what are the grounds for the revocation? Ako, ang dami. Ang dami niyan. Okay? Hanggang letter I. Pero by the way, para hindi ka na mag-memorize, ito na lang ang tandaan nyo. Rule of thumb lang tayo. Mapapansin mo, kung ako yung Security and Exchange Commission, at ikaw ay foreign corporation doing business in the Philippines, syempre, kung ako si SEC, I can require you some reportorial requirement. Kaya may mga requirement na i-issue ang SEC para i-comply ng foreign corporation. Ang problema, yung foreign corporation ayaw mag-comply. Kaya mapapansin mo, puros failure siya. Failure, 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 and failure. Okay? Or second, nagko-comply naman si foreign corporation, pero nagmi-misrepresent siya. Kaya papasok yung misrepresentation. Okay? O kaya naman, nagko-comply siya, wala siyang misrepresentation, pero nag-ooperate sila outside the license given. Kasi hindi naman porque may license yung foreign corporation to operate, they can engage in any kind of operation. O kaya ina-allow nila yung other foreign corporation na gamitin yung kanilang license, which is not allowed. Or pinaka-broad na talaga, lahat ng act na gagawin ng foreign corporation na magiging unfit sila to do business in the Philippines, then the SEC may revoke their license. At ang legal effect, once na ang SEC ni-revoke ang license ng foreign corporation, isa lang ang effect niyan. Okay, they cannot sue, but they can be sued in any court or any administrative agency. Pero take note, required lang ang foreign corporation na mag-obtain ng license if they are doing business in the Philippines. And pag sinabing doing business, dapat may continuity ng transaction, at second is for the economic benefit. Kaya ibig sabihin, kung ito yung mga isolated transaction lang, hindi yan mako-considered as doing business in the Philippines. Pero kung nagkaroon ka ng announcement na mag-ooperate na kayo here in the Philippines, then before the foreign corporation can operate, kailangan meron silang license to operate. Okay? The end of corporation law. Now, of course, we will discuss, our next topic would be cooperative. Okay? Yung Republic Act 9520, the Philippine Cooperative Code of the Philippines of 2008. Okay? By the way, gagawa ako ng separate video for the multiple choice problem. Okay? Okay, break muna tayo.